The defense rests. Let's play hardball. Good evening. I'm Michael Smerconish in for Chris Matthews. It's day 22 of the George Zimmerman trial. The defense has rested and George Zimmerman has chosen not to testify, although not before a tense exchange between Judge Deborah Nelson and defense attorney Don West as the judge asked Zimmerman whether he wanted to testify on his own behalf. The prosecution is now scheduled to begin its closing arguments tomorrow at 1 p.m. Eastern Time, while the defense is to start on Friday morning. In addition, prosecutors are saying they would like to include the lesser charges of manslaughter and aggravated assault, but the defense has objected, so that will likely be settled tomorrow. Today was a day in which both prosecution and defense attorneys used a mannequin to demonstrate what may have happened between Trayvon Martin and George Zimmerman before the gun fired, killing Martin. Dennis Root, a public safety expert called by the defense, testified that the physical capabilities of George Zimmerman were weaker than those of Trayvon Martin and that Martin was in better physical condition. MSNBC's Craig Melvin has been monitoring all of today's proceedings, and he joins us now from the Florida courthouse. Craig, we will not be hearing directly from George Zimmerman.
No, Michael Smerconish, that was the headline today, good sir. Good evening to you. George Zimmerman telling Judge Nelson this afternoon that after consulting with his attorneys, he decided not to testify on his own behalf. 18 defense witnesses, 38 witnesses for the state, and now it appears as if this case will be going to the jury at some point tomorrow. Judge Nelson told the jurors shortly before she released them, and she said she's going to bring them back at 10 a.m. tomorrow morning, but shortly before she released them, she said that closing arguments in this case will start tomorrow. That means that best case scenario, they could get the case tomorrow. Worst case scenario, they'll get it sometime on Friday. Dennis Root, you mentioned the witness that testified, a self-proclaimed use of force expert, a retired law enforcement officer as well, basically testified that based on the evidence that was given to him, George Zimmerman's story checked out. The information that was given to him, of course, was given to him by the defense. He was a defense expert witness paid by the defense, but he was given a number of pictures, and he also interviewed George Zimmerman, and he also looked over some of the witness statements as well. He was asked pointedly by Mark O'Mara, the attorney, of course, for George Zimmerman, ill will, spite, or hatred. Based on what you've heard, based on what you read, was there ill will, spite, and hatred in his voice when he made that call to the non-emergency number?
Can I say I was shocked as a lawyer watching that he was allowed to answer that question. That, to me, didn't seem like the sort of thing you ask a so-called expert. That would be left for the jury.
And there have been a number of attorneys who said the same thing today, Michael Smerconish. Not just that question, a number of other questions as well that he was asked and allowed to offer an opinion on that would seem to be outside the boundaries of his area of expertise. And we should also note here that he apparently contacted the defense as well. He became familiar with the trial. He raised his hand. He called Mark O'Mara and he said, I would be very much interested in being a witness for the defense.
Well, you and I talked last night at this time about the fact that very much they wanted to get an animation. The defense wanted to get in a computer animation to recreate what they allege took place. They're not allowed to use that animation except in their closing argument. And I guess Dennis Root was then introduced in lieu of that animation. They were trying to get in through him what they had hoped to get in through the computer animation that was disallowed.
That would seem to be the case. And as you indicated, Judge Nelson ultimately deciding that the animation, again, at this point, it's our understanding that was a fairly elaborate animation has been reduced to some stills, and part of the stills are animated. It's not nearly what it was in the beginning, but that's going to be something that the jury can see in the closing. Not going to be something, though, that the jury is going to be allowed to take back in the jury room with them, since Judge Nelson said it cannot be used as evidence. It was also interesting, Michael, that the defense decided to essentially end their case the same way they started the case. Of course, they started their case with Gladys Zimmerman, George Zimmerman's mother, and they ended with Robert Zimmerman Sr., George Zimmerman's father, and both of them essentially called to testify that it was their son's voice on that 911 call. And by the way, we kept count. Robert Zimmerman Sr. was the 10th person for the defense to testify that it was his son's voice, and that is obviously going to be one of the central points that they make to the jury when they address them tomorrow in their
Craig,
closing
great
arguments.
report as always. Thanks so much for it.
Thank you, Michael.
For more on today's testimony, I'm joined by MSNBC legal analyst Lisa Bloom, former Florida Circuit Court Judge Alex Ferrer, and criminal defense attorney Joseph Haynes Davis. For the three of you and everyone else, I want to take a look at that exchange earlier in which Judge Nelson questioned George Zimmerman about whether he wanted to testify and the back and forth between defense attorney Don West and the judge.
Mr. Zimmerman, have you made a decision as to whether or not you want to testify in this case?
Not at this time, Your Honor.
Okay, and when is it that how long do you think you need before you make that decision?
Your Honor, may we have an opportunity to speak? The case isn't concluded yet.
I understand that, and I've asked Mr. Zimmerman if he needed more time to talk to his attorneys, and if he does, I will afford it to him. Mr. Zimmerman, how much more time do you think you're going to need to discuss this with your attorneys?
I assume it would depend on how long the recesses are, Your Honor. At the end of the day.
Okay, well, if your attorneys have finished with 2 witnesses before the end of the day, do you think that you would then know whether or not you want to testify?
Your Honor, on Mr. Zimmerman's behalf, that decision...
I am asking your client questions. Please, Mr. West.
I object to the court inquiring of Mr. Zimmerman as to his decision about whether or not to testify.
Your objection is overruled.
Judge Alex Ferrer, you have been in that position of advising a defendant of their Fifth Amendment right. I want you to read those tea leaves. What was going on there?
There is an underlying current of friction between the two of them. Clearly, it's been present throughout the entire case, and it just bubbled to the surface today, like it has on other occasions. The judge doesn't need to know right now. There's still 2 witnesses left. He can wait and make his decision at the end of the 2 witnesses. But by the same token, Mr. West really didn't have to make a point of it, because even if he said, I don't really think I want to testify right now, he could change his mind, and later on after 2 witnesses, I changed my mind. So it doesn't really matter. It's just, it seems like each one of them was playing on a power play against the other, and it just bubbled up.
Joseph Haynes Davis, I watched that and I said to myself, if and when George Zimmerman writes his book, the story I expect to hear is that he wanted to take the stand and his lawyers didn't want him to do so, and we just saw a representation of that. How did you read that moment?
Well, I read the moment, Counselor, and thank you for having me, as Judge Nelson saying, look, this is my courtroom, and pardon me for using some vernacular, I'm not playing with you. I mean, she's in charge of the courtroom. I've practiced in front of Judge Nelson periodically a couple of times. She's a very, very good judge. She's a very, very honorable judge. And she's a very, very smart judge in terms of knowing where she wants to go and how she wants to conduct that courtroom. And I think in that instance, it was Judge Nelson saying, look, this is my courtroom. This is how I'm going to conduct it. I understand your client's Fifth and Sixth Amendment rights. I'm not going to trample over those rights, but I am going to conduct this courtroom the way I'm going to do it, and you just need to sit there and let me do it because I am going to do my job.
Lisa Bloom, help me get into George Zimmerman's head if you can. I mean, I find it very hard to believe that with 90% of the defense case in, he still doesn't know whether he wants to or is going to take the stand?
Well, it's possible. Look, he hasn't had a lot of time to talk to his attorneys because they've been fighting this case yesterday until 10 p.m., and he's got a curfew. He has to go back home. In fact, his curfew had to be extended last night. If I can defend Don West for a moment, who I think is also an outstanding attorney, I think he's an honorable person. He's not a potted plant. He's there to fight for his client, and he's essentially trying to say, you know what? It's too early. Don't put my client on the spot like this in front of the national media. He shouldn't have to answer this question until the final witness for the defense is called. So don't put him on the spot. I mean, that's what Don West was trying to say.
Hey, Judge Alex, this Dennis Root who testified today, the defense expert, and I've got to believe because they couldn't get the animation video in as evidence, they tried to get in through him what they wanted. I don't, you know, you're the judge. I've tried cases. It just seemed to me like he went way beyond the bounds of what I would expect to hear from an expert. Were there aspects of his testimony that you found yourself saying that's really not something you'd look to an expert to answer?
Absolutely. He was allowed to testify about all kinds of things.
Yeah.
He got into the psychology. Some of the things he got into, the prosecution frankly didn't object. They just sat back and let the questions be asked. Leading questions, questions beyond his expertise, non-responsive questions where he continued. They would ask him one question and he would expand into entire areas. Some of the questions they did object to, and Judge Nelson allowed it in, but basically they fought to keep out the animation, and then they ended up doing a reenactment with a dummy in front of the jury and allowed the defense to do the same. I'm not really sure why they were so lenient on this witness.
Mr. Davis, how could he speak to the physicality of Trayvon Martin versus George Zimmerman and who was in shape and who wasn't in shape and so forth, essentially saying who would have had the upper hand in a fight like this?
I tend to agree with you. I mean, that to me is not very possible, but I think that this jury will be able to put that in perspective and weigh it when they go into their deliberations. I agree with you that you know, it was a bit peculiar with the testimony of Mr. Root and his scope of his testimony and so forth. But I think that this jury will be able to see through that and see and tell that, listen, the deceased victim cannot testify himself and say who was the stronger individual.
Lisa Bloom, you have been talking extensively about the gun position and so forth, and I couldn't wait to ask you about this. Assistant State Prosecutor John Guy used a mannequin to reenact the encounter between George Zimmerman and Trayvon Martin. Let's watch this.
If this person, this mannequin, were carrying a firearm on their waist, where would the gun be right now in relation to me?
Would be at your left inner thigh.
Right here, right?
Yes. If he was right-handed, it would be at your left inner thigh. Yes, sir.
Right. Underneath my leg.
Yes, inside your leg.
Okay. Were you aware that the defendant described to his best friend that when he slid down, the defendant slid down, that Trayvon Martin was up around his armpits? Were you aware of that?
No, I've not heard that. No, sir.
Okay. Well, where would the gun be now?
Now the gun would be behind your left leg.
Okay.
Lisa Bloom, you told me on Monday night on Hardball that you'd gone back and reread aspects of this case and that you thought something had been overlooked thus far by the prosecution. And when I saw that today, I said, this is what Lisa was talking about.
Yeah, I know. I was hoping that John Guy was going to do it in the courtroom today, but he didn't. On the reenactment video, when George Zimmerman is asked where he holstered the gun, he demonstrates apparently reaching back behind his right hip to his back side. Okay, so this witness had it wrong, and the prosecution was not able to correct that because they apparently are not aware, at least so far, unless they're saving this for a big moment in closing argument, that George Zimmerman had the gun holstered not only inside his pants, covered by a shirt and a jacket, but on the back side of his hip. That's where he demonstrates on the video with his hand that it was. I want to say something else about the mannequin. I don't like the fact that the prosecution is really conceding the defense version of the case. We have the prosecution on top of the mannequin, just like the defense attorney did. They didn't use the mannequin. I would have had it standing up, because that is one theory of how this fight happened and when the shooting could have happened. I would have had George Zimmerman on top, as a number of witnesses had him, and Trayvon Martin on the bottom. I would have had it moving it around in a dynamic situation. I mean, to just do it the same way the defense did, I think gives the jury the impression that everybody's now on the same page, that at the time that the bullet was shot, George Zimmerman was on the bottom, Trayvon Martin was on the top.
Well, Joseph Haynes Davis, to Lisa's point, I have been surprised at just how much of George Zimmerman's version has been able to come into evidence in this case. Now, I recognize he gave police statements and a reenactment, but truly, for what purpose would he have testified? Because his version of events has so clearly been put in the record as the example she just illustrated.
I think Ms. Bloom is correct in that it is a little bit interesting, to say the least, that there was nothing being distinguished by the state's turn with the mannequin. And, Counselor, you are absolutely correct. Listen, George Zimmerman has testified, so to speak, by the statements that have been played over and over again with his interviews, with the Sean Hannity interview, I should say, and much, much more. So he has no reason to testify at all. As to whether or not he really thought about it when he didn't know what to say when the judge asked him, well, we will never know that because we will never know that.
Closing arguments tomorrow. Thank you so much, Lisa Bloom, Joseph Haynes Davis, Judge Alex Ferrer. Coming up, remember way back to November when Mitt Romney won the support of just 29% of Latinos and Republicans vowed to win them back? Well, fast forward to today when much of the GOP has decided that immigration reform will just create more Democrats. Reform could be dead, and with it, Republican presidential hopeful in 2016. Also, you may love Walmart, you might hate Walmart. Few people are neutral, so pick your sides as the giant retailer battles the local Washington, D.C. government over whether it should be forced to pay its own higher minimum wage. Walmart is threatening to pull out of the city. And it may be nothing more than a cry for attention, but Sarah Palin is talking about a Senate run.